Companies Act, Section 349, Mandatory Deposit of Liquidation Funds into the Public Account of India by Official Liquidator. Section 349 of the Companies Act, 2013 outlines a crucial responsibility of the official liquidator, which is the mandatory remittance of all funds received during the liquidation of a company into the public account of India maintained with the Reserve Bank of India, RBI. This statutory requirement ensures that the funds handled by the official liquidator are secured, transparently managed, and centrally monitored by the government, safeguarding the interests of creditors, contributors, and other stakeholders in the liquidation process. 1. Who is the official liquidator? The term official liquidator refers to an officer appointed by the central government and attached to the tribunal, the National Company Law Tribunal, or NCLT, for the purpose of conducting winding up proceedings. The official liquidator acts as a public servant and is entrusted with the responsibility of collecting, protecting, and realizing the company's assets, discharging its liabilities, and distributing the proceeds in accordance with applicable provisions of the Companies Act and orders of the tribunal. The official liquidator is distinct from a company liquidator, who may be appointed in voluntary winding up or by the tribunal from a panel of professionals. 2. Statutory duty to deposit money with RBI. Section 349 imposes a mandatory obligation on every official liquidator to deposit all funds collected during the course of liquidation into the public account of India maintained with the Reserve Bank of India. Key requirements. Scope of funds. This includes all monies received in any capacity as official liquidator of a company undergoing winding up. Such monies may include sale proceeds from assets, recoveries from debtors, dividends received, funds realized from enforcement of claims or settlements, any income or receipts arising during the liquidation. Depository institution. The money must be deposited into the public account of India, which is maintained by the Reserve Bank of India, RBI. Manner and timing. The actual manner in which the payments are to be made, including the prescribed frequency, procedure, formats, documentation, and timelines, shall be laid down by the relevant rules framed under the Companies Act, 2013 or as notified by the central government. This ensures that there is a clear audit trail and centralized control over liquidation funds, which are public in nature once realized by a statutory officer. 3. Purpose and significance of this requirement. The requirement under Section 349 serves several important regulatory and financial objectives. A. Financial accountability. It enforces strict oversight of public funds handled by the official liquidator. Depositing funds in the RBI's public account reduces the risk of misappropriation, delay, or private holding of such funds. B. Transparency and traceability. Ensures that every rupee collected in the process of liquidation is traceable and auditable. Maintains a transparent accounting trail to support proceedings in the tribunal and financial statements related to liquidation. C. Protection of stakeholders' interests. The funds realized during liquidation are primarily meant to satisfy the claims of creditors, employees, contributors, and other stakeholders. Routing such funds through the public account of India ensures they are held securely until distribution as per the order of priority under the Companies Act. D. Facilitation of statutory distribution. When the money is held in the public account, its utilization or disbursement can only be done in compliance with the legal procedures, such as order of the tribunal, application of claims, clearance of dues as per sections 326, 327, and other relevant provisions. 4. Rulemaking authority and procedural compliance. The central government, under the rulemaking powers conferred by the Companies Act, is authorized to prescribe the manner, format, and frequency of payments made by the official liquidator into the public account. These rules may address the timelines for depositing funds, example, daily, weekly, or upon receipt beyond a certain threshold, modes of transfer, example, NEFT, RTGS, demand drafts, submission of bank receipts or certificates, maintenance of deposit registers, and reconciliation processes. The official liquidator must maintain accurate and timely records and comply with any audit or inspection required by the tribunal or the Controller and Auditor General, CAG, where applicable. 5. Consequences of non-compliance. Although Section 349 does not explicitly lay down a penalty provision, failure to comply with this requirement may lead to disciplinary action against the official liquidator by the central government or the tribunal, adverse findings in audit or inspection, obstruction in the liquidation process, or delay in disbursing funds to claimants. Initiation of contempt proceedings or action for breach of fiduciary responsibility, application by stakeholders to the tribunal for directions or substitution of the liquidator. The tribunal may also direct rectification and recovery of funds or any loss caused by the delay in making deposits. For more details, contact us.